Assalamu alaikum. My name is Ken Adams, and welcome to Drafting Clear Contracts. It'll be an exciting day, I promise, if you like contracts. It's a great pleasure to be here. This is my first visit to Saudi Arabia. My grandfather was a scholar of Islam and wrote a book about 80 years ago that's far too complicated for me to read. My father grew up in the Middle East. He lived in Saudi Arabia for a bit. He spoke Arabic. One of his hobbies was Arabic calligraphy. But unfortunately, that cultural knowledge stopped with me. I was deprived. But I'm pleased that in the last 10 years, what I do has brought me to this region quite a lot, and so in particular that it brought me here today. So thank you. And in particular, it's a pleasure to be to be hosted by the Saudi Center for Commercial Arbitration. Contract provisions are obviously particularly relevant for arbitration, namely dispute resolution provisions. So we will be talking about that later. We're going to adjust the schedule a little bit. Instead of what's called the drafting exercise at 4 o'clock, instead we're going to talk about arbitration provisions. But obviously we're taking the opportunity to do more than that today. Instead, we're going to look more broadly at how contract language works or doesn't work. A couple of general notes. Let's see. Contract language matters if contracts matter. So at some points during the day, you might ask yourself, why on earth are we talking about this small issue that seems petty, seems a small thing for people to be worried about? But if contracts matter, if enough is at stake, if enough money is involved, people are going to fight about it. The language of contracts is limited and stylized, and if enough money is involved, people will worry about how individual words and phrases work. So I guess I suggest to you that during the course of the day, you just ask yourself, do the contracts you work with matter? There are places in the world where contracts don't matter. But my sense is Saudi Arabia, particularly with large international contracts, they will matter and people will care about them. And if they care about them, they'll care about the language. Also, a general note for non-native English speakers. I have bad news for you and good news. The bad news is that everything matters in contracts. If you were learning beginner French, for example, you would start off by learning how to say, "Good morning, would you like a cup of tea?" And that's fine, and then you build on that. But with contracts, it's sort of like you're either standing on the sidewalk watching the cars go by, or you're on the highway itself. You're on the highway. You are handling contracts completely. There are no baby steps for contracts. So if you're dealing with English language contracts, you're either not dealing with them or you're dealing with them completely. So we are going to be talking about some complicated things today, simply because you have no choice. If you want to handle English language contracts, you have to be able to recognize these things, because otherwise things can happen without your being aware that they are happening, or you can find yourself exposed to risk without realizing it. But the good news is that drafting a contract is not like writing some big English language novel, some story or play or poetry. The language of contracts is limited and stylized. It's a little like software code. So with just some basic understanding of certain principles, you can greatly increase the chance of staying out of trouble and being able to accomplish your goals. Okay, now, why am I here talking about this thrilling subject? I worked in large American law firms doing transactions when about 20 years ago I decided that I found more interesting how contracts work and don't work, how the language works and doesn't work. So I started paying more of my attention to that rather than quickly doing transactions. And that's now what I do for a living. I've done it for the last 12 years. What do I do? Well, I travel around the world speaking to groups such as this. It used to be Chicago one month, New York the next month, but now it's Riyadh, Sydney, Copenhagen, Shanghai. Be a contract nerd and see the world. I consult with companies and other organizations in terms of improving their contract process, improving their contract templates, and I write stuff. The most obvious expression of the writing urge is the handsome red book you have in front of you. That's the third edition of a manual style for contract drafting published by the American Bar Association. Inshallah, the fourth edition comes out next month. 100 extra pages. It just gets bigger and bigger. If you ask the partners for this event, the Commercial Law Development Program of the U.S. government, whether you can have the fourth edition, they might be nice to you. But today's session is going to consist of just a look at some of the topics discussed in the book, just to introduce you to my approach to contract language and to make the book more helpful to you as a reference tool going forward. In terms of you guys, I realized I switched off my phone, but now I have it's a very useful way of, in my new phone, it provides a useful way of keeping track of what the time is, so I'm turning it back on. Who here works regularly with English language contracts? Just so I have a sense, just show of hands. Okay. Some of you, it's possible, excuse me, make sure it's on mute, and it's on mute, fine. Some of you might not be familiar with contracts and are here just as an adventure. I hope you don't find the day too shocking. So it's a different kind of language. Now we're going to spend a little bit of time considering what contracts are like now. So the current state of contract drafting, it's not good. We're going to spend the day exploring what I mean when I say that, but just contracts are not as clear, are not as concise as they should be. I make myself a bit of a nuisance in that I regularly look at what is out there. Contracts drafted for big deals, contracts prepared by big companies, and I take them and I look at them, and I always find problems. Big problems, even when companies are I think that they're doing something new and great. For example, a couple of years ago, I looked at IBM's new cloud services contract. They were very proud of it. And of course, I always win friends and influence people by taking something and looking at it and writing on my blog my explanation of why I think something is just not as good as people think it is. So that's what I see. And why do we care about it? Because if a contract that you're working with has the usual problems of traditional contract drafting, the result is that you're going to have confusion and delay at every step in the process. When you're drafting the contract, when you're reviewing it, when you're negotiating, when you're monitoring performance under the contract, delay and confusion. So necessarily that is going to waste time, waste money. And if an organization's contract templates have those problems, you're going to have that delay and confusion spread throughout the system, potentially wasting a lot of time, a lot of money. It can hurt your competitiveness. And then there's the issue of contract parties who find that because of some problem with the drafting, they're not getting under the contract what they expected to get. And if they're unhappy enough about it, they're going to fight about it. And my book is full of dozens of examples of contract parties who unexpectedly found themselves in court fighting over some seemingly small drafting problem that somehow turned into a big dispute. How can it be that there are these problems? Well, any new transaction is going to closely resemble other transactions. So when a new transaction comes along, the instinct is to get contracts for other transactions that have already been done. You take those contracts and you copy them and you make changes for the new transaction. That sounds like it should be a source of efficiency. But the problem is, when you're dealing with word processing for contracts, what you're doing is you're copying and pasting. People don't have the time, the interest, the expertise to, when they take an old contract, to go through and say, we're going to make sure everything works, we're going to make sure we understand everything. Just people don't have, they're just not in a position to do that. So instead, they copy, they assume it's going to work. It worked before, so it's going to work now. I don't understand a lot of it. Well, that's probably just because that's my problem, and I don't want to look stupid, so I'm just going to assume it all works. And that's the way it works, generation after generation, everyone assuming it works. There's a story in a European fairy tale, The Emperor's New Clothes. And the emperor walks around and says, how do you like my new clothes? Everyone says, oh, they're wonderful. The emperor is, in fact, not wearing any clothes. And a little boy says, the emperor has no clothes. So it's just everyone is just copying and pasting and not really understanding, but they assume that's the way it works and it must be the right way. So today we're going to perhaps consider the emperor without the clothes. In fact, copying and pasting gives rise to a behavior that I call passive drafting. When you're copying and pasting, the way it works now is you don't have guidelines for contract language because you're copying. Who needs guidelines if you're copying? And similarly, you don't train people in contract drafting because they're copying. You don't need to be trained to copy. And what you copy might be different from what I'm copying, so we have to have an explanation for that. What I generally hear is the idea of drafting style. Senior lawyer tells junior lawyer, you'll develop your own drafting style over time. I'm not a fan of the idea of drafting style, because to express any concept, there's going to be one best way of doing it and a bunch of less clear ways. And my book is a catalog of here are all these different ideas we have to express. Here's the clearest way of doing it. Here are all the less clear ways. My drafting will be better if I use only the most clear ways, and contracts as a whole will work better if everyone uses only the most clear ways. So drafting styles, no, it's an excuse. It's not an explanation. And a lot of the traditional language looks strange. So we have to have an explanation. We have to justify that. And the main way people do that is by invoking the notion of a tested contract language. The idea there is, oh, okay, this language might look strange, but the courts have told us what it means. And if we change it, that'll be very risky. That sounds like it might be sensible. But what a court has to say about a confusing bit of contract language is going to depend on the circumstances of the dispute and how smart the judge is. So courts in different parts of the world have different things to say about the same bit of contract language. So if you're expecting a court to come in and tell you what your contracts mean, you might be on very uncertain territory depending on what part of the world you're in. And even courts in one country might say different things over time about the same bit of contract language. And just generally, it's a little strange to say, this contract language created a fight, but we're going to keep using that confusing contract language. I don't want to use contract language that results in a fight. My job is to stay out of fights. So I'm going to express the deal clearly in a way that the parties can understand it without requiring an interpreter to come in from the outside to say what things mean. And there's also the notion that, well, the traditional language looks the way it does because it's precise. Contracts regulate conduct. They have to be particularly precise, and the traditional language is very precise. But if you compare the traditional language to the alternative is always clearer. What is the alternative? It's standard English. English as spoken and written by the average native English speaker. I make a point of not using the phrases plain English and plain language, which you might have heard, simply because a lot of transactional lawyers will hear plain English and they think, oh, that means English written so everyone can understand it. People in the street can understand it. And I, the lawyer, I'm not going to dumb down my contract language. That's not the idea. Contracts, transactions can be complicated. And a contract is going to have to be as complicated as the transaction it needs to express. But nothing is gained by expressing that complexity in the very strange form of language that is traditional contract legalese. It's just a matter of it's not a matter of dumbing down language. You just use regular English to say what you need to say. So what is the alternative to passive drafting? It's active drafting. We're using standard English. We're following a set of guidelines, and my book aims to be that set of guidelines. We train people in drafting and reviewing contracts consistent with the guidelines, and we express the deal clearly so the parties can understand it. Some things to bear in mind for today's session. we're going to be focusing not on what you say in a contract, but how to say clearly and effectively whatever you want to say. So we're not going to be talking about intellectual property or oil and gas or anything like that. Just how to say clearly and effectively whatever you want to say. Some of the things we're going to talk about are going to be important general principles, but we'll talk about some other things that are just examples of some of the many decisions anyone drafting a contract needs to make. Any particular decision might not be particularly important, but all those decisions taken for an entire contract have an important cumulative effect on how the document is to read. We'll talk later about, okay, what do we do now that we've talked about what clear contract language looks like. I'll mention a couple of things up front. How you approach contract language depends on whether you're drafting or reviewing. I'm sure some of you draft, some of you review, some do both. When you're reviewing, it's not your job to turn the other guy's contract into a thing of beauty. Instead, you just focus on possible sources of confusion or things that don't reflect the deal as you understand it, but you leave everything else alone. But I suggest that even if your job is reviewing, it's best to have a general understanding of how contract language works, and then you pick your battles. It's best to be an informed consumer of contract language, and that's the way to look at today's session. My aim is to help you become an informed consumer of contract language if you aren't already. There's also the issue of how are other people going to respond to what we talk about? I wouldn't be doing these seminars if I thought that was a big problem, but still, we're in a very conservative profession, and you can expect some people to say, hey, why are we doing it this way? So we'll talk about that at the end of the day. But just bear in mind that for most of today, the focus is on figuring out what makes sense. And then later we'll talk about, okay, so how do we convince people to use what makes sense? I'm based in the US, but I'm not an ambassador for the American way. Instead, I look at the way people do things the world over and take what I think makes sense. I found that in much of the world, those drafting contracts tend to copy either a US approach or an English approach. The differences are mostly in the look of a document, because the language of contracts in English the world over is pretty much the same. But there are some differences in approach that we'll talk about today. I include in the presentation examples from American contracts and from English contracts. I included in, the first chapter of the book is on characteristics of optimal contract language. Just introducing the reader to the idea that this is a limited and stylized kind of writing, and there's some special considerations that apply. Any kind of writing aims to be clear, but one issue for traditional contracts is why the old-fashioned stuff? There's still so much old-fashioned stuff in contracts. But we're in the 21st century, a time of lots of change, great competitive pressures in business, with companies and industries rising or falling just depending on just some little bits of efficiency. If that's the case, it's strange to have companies that are fighting for market share in that sort of environment using contracts that look like they have things from 200 years ago. I like to see contracts that are as modern as the businesses they serve. Redundancy. That relates to the urge to use 5 words instead of 1. We can understand how that happens. Lawyers famously don't like risk. Which of these 5 words do I use? I don't know. Let's use all of them just to be safe. And then they use all of them and they look at it and they say, hey, that makes me look particularly smart. You need me to help you through this strange document I've created. So we understand how redundancy comes about, but we have a job to do. We have a transaction to express. Let's use whatever word or words we need and move on. Similarly, don't say the same thing twice. If you do, you're adding unnecessary words. And if you say one thing here and say it over here again, but a little differently, don't be surprised if you end up in a fight over what the implications are of that difference. So don't say the same things twice. So those are just a couple of the implications of the specialized kind of writing that you find in contracts. All right. That was the gentle introduction. Now we are going to get into the detail, because it's impossible to talk about contract language in general, theoretically. You have to look at the words, at the phrases. We're going to start with the front and the back of the contract. Not the most exciting part of the contract, but I like starting with the front, not just because, hey, it's at the front, but because the front of the contract has some of the strangest aspects of traditional contract drafting. So looking at the front helps draw a distinction between a traditional approach and a more modern approach. Now, so that was, I did a lot of talking. I encourage you to ask questions, make comments at any point. I've structured things that I'm going to, encourage. I'm going to ask you questions and encourage you to speak up. But so please do so. Don't hesitate. Here's the introductory clause. By the way, MSCD, the initials for my book. Here's my introductory clause. What do I have in it? I say what kind of contract it is. It tracks the title. I use a date. I have the party names in all capitals. And I have the jurisdiction of organization. I want to make it clear who the parties are to the contract. By the way, one dramatic change for the 4th edition of my book. See this date format? That's the crazy American month, day, year format. For the 4th edition, I'm saying day, month, year, just because to join the rest of the world. Even the U.S. military and the U.S. State Department use day, month, year. So enough with the old style. One thing I don't have in the introductory clause is party addresses, because all I want to do is identify the parties. Use whatever information is relevant. We're a little backwards in the U.S. We don't have registration numbers, for example. So if you have registration numbers, then that's relevant information to include as well. It all helps to identify who you're dealing with. But addresses aren't necessary. I mean, if the contract discusses notices being sent between the parties, there'll be a notices provision, and that's the place to put party addresses. I don't want to clutter the introductory clause with information that isn't relevant. Now, here is certainly.
I have a question regarding this clause. Some contracts add some additional.
By the way, when you ask questions, please speak into the microphone to make the interpreter's life a little easier. Go ahead.
Some contract start the contract by a clause. This contract is entered by and between. So this word, does it mean?
I think that's an interesting question. I don't think, I have a slide for that in my U.S. seminars. I thought, they're not going to be interested in that. So we'll talk about that, but in a moment.
Okay.
Yeah, we'll talk about that just in a couple of minutes. All right, this is a traditional U.S.-style introductory clause. Would you like to suggest ways that you think well, what elements in it you think I would want to change? Just suggest something. Yeah, this has addresses, and I say, we don't need the addresses because they'll be in the notices provision. So no addresses. What else?
But you're assuming that there'll be notice provisions. Right?
Yeah, yes. I mean, if there aren't any notices provisions, I'm not going to need the address anywhere, because if the parties don't need to contact each other, the information in the introductory clause will make it clear who I'm dealing with.
Sure, but if there's a dispute, then how do you deal
Well, if there's a dispute. By the way, you don't have a microphone, so and if you don't have a microphone, I'll make sure I repeat your question. If I'm not going to feel the need to have party addresses, I mean, because I know who I'm dealing with. If the address isn't relevant for the contract, if I need the address, hey, I'll look in my I'll look in my contacts file. If the address isn't important for for contract purposes, I'm not going to include it just because I have to put the address. I know who I'm dealing with. That's the major thing. Yeah.
Hi, Ken. My name's Abdullah. I think the issue with addresses is that it's become a matter of habit. Every law student and every lawyer is used to seeing agreements with addresses particularly in the introductory clauses. So everyone's just assumed that.
Yes. Okay. I'm in the business of breaking habits, because there are all sorts of crazy habits that we will discuss during the day. So I figure if we're in the business of if I'm asking people to change habits, there's a American expression about not teaching old dogs new tricks. So I make a point of not asking people to make changes that don't have value. But I think it's worthwhile enough to not clutter up the introductory clause with stuff that is just not necessary or is not in the relevant place. So I think that's not too big a change for me to ask people to make. But habit, we will encounter you during the course of the day. We'll discuss all sorts of habits that I'm going to suggest you can change. What else? What else can we change about this?
It's about the, I think, the wording style. It's more about
The wording style. Oh yes.
just this agreement.
Yeah, this agreement says here, I think that there's a redundancy here.
Oh, okay.
This agreement in
All right,
lieu
hey,
of
you're,
the agreement.
That's a bold suggestion. Are you familiar with what I do at all?
Not at all.
Well, then, your instincts are impeccable, because normally I mention this kind of at the end as a big, climax to the discussion of this slide, because it's actually, it relates to something that they talk about habits. First, let's look at this consulting agreement. Lawyers like giving initial capitals to things that are important, and there's nothing more important than this consulting agreement. So there's a capital C, capital A. But as a matter of English, there's no point to it. If I say this table has a wooden top, table, small t, not capital T, this consulting agreement is dated, I'm going to use lowercase letters. It's just a thing. It's like, I received this letter from my mother, small l. I don't need initial capitals. Then we have this agreement. You see this in all the contracts you deal with? Every one, I'm sure. This is a defined term. We'll talk about defined terms later. Defined term is a label you use for a longer concept, just so you can state the concept more concisely and consistently in the contract. What is the longer concept underlying this agreement? It's this agreement. There is no longer concept. I'm going to start out by saying this consulting agreement, but then elsewhere in the contract, I'm going to say just this agreement, just to be shorter. And I don't, just as I can say this consulting agreement with small letters, I can say this agreement with small letters. I say this agreement small a. So I don't need this, and I don't need the capital A. Now, in the US and in England, people are disturbed by this. And that's one of the two most alarming things I suggest to people. Sometimes I see people looking around like, am I really hearing this? We must stop this madman. But it's just, as a matter of English, English usage, there's no possibility for confusion. If I get rid of this agreement here, and I say this agreement small a, I eliminate a bit of clutter and I make the contract easier to read. So it's positive. But I'm mentioning this mainly as to suggest a general principle. If you're doing this agreement thing and the initial capital letters, you're not doing it because it makes sense. You're doing it because you're copying and pasting. You're doing it because, well, this is the way it's always been done, so it must be right. In other words, you have a deferential approach. You're assuming that stuff that's in contracts you work, the stuff that you see regularly, it makes sense. And if you have that approach here, and this doesn't really matter. Cleaning this up makes the contract a little bit easier to read, but there's no big issue. But if you're doing this here, I guarantee that you're doing this, you're bringing to bear the same deferential approach elsewhere in the contract in connection with issues where there's more at stake. So this is just a matter of just showing you that just doing things the way they've always been done doesn't make sense, and it's that way throughout the contract, and we'll discuss more important examples of that. Yeah.
And maybe that doesn't matter in a case where there is no reference in the contract to another agreement.
Okay.
But sometimes there is many
Sure.
references
Well, of course.
to other agreements.
Of course. Well, thing is, this is this agreement. The other agreements are the distribution agreement dated 25 October between Acme and Wigico, or there's this agreement or that agreement, and if you refer to them enough, you might create a defined term, the Acme distribution agreement. Those are all those other contracts. There's only one this agreement, and there's no possible confusion because there's this agreement and the others. So it's
This may cause to repeat the name of the other agreement a couple of times.
well then, but that has nothing to. That's those references. As I said, if you mention them enough times, you can create a defined term for another agreement and call it the Acme distribution agreement. But those are those other agreements. There's this agreement is something else. This agreement is this agreement, and there's no possible confusion between this agreement and the other agreements. And this agreement is the simplest way to refer to this agreement. It's this agreement. It's not those agreements. So there's no possible confusion.
And I'm also have a comment on made and entered.
Oh, you're moving. Okay. You're moving on. So, again, in the U.S., there's some people who just say, oh, "I'm going to have to think hard about this." Some of these are. With some of these changes, it's just a matter of breaking habit. It's just a matter of waiting. Okay, I have to breathe deep. Prepare myself to make the change. You make the change. You wait for something bad to happen. It doesn't happen. And then you realize, hey, life's a little simpler. Things are a little clearer. And the spell is broken. And then the next challenge is convincing the person who reads the contract and says, this agreement, small a, what craziness is this? But we'll talk about that at the end of the day. Now we're just trying to figure out what makes sense. Made and entered into.
I think it's we need to make it more simple.
You don't like is made and entered into?
Can use dated.
Welcome to the world of redundancy. First we made the contract, then we entered into the contract. It's like first we built the cabin, then we entered the cabin. No, it just
the same problem in
dated. So I'm going to say is dated. This consulting agreement is dated. Yeah. What else?
That's it for me.
Okay. What else? Anything else you want to point out? What? Sure. What, you don't like the 15th day of January? Sounds like a very important day. How about just 15 January? And what do you think of this?
It's this one.
Sorry?
Yeah, I just was mentioned the state where the
Okay.
corporation-
So what are you referring to? So what
corporation organized person to the law.
okay, so what do you want to do? What do you want to do with that?
I mean, it may matter if
Oh, I'm saying we keep. I want to keep it in there.
if it is computerized.
Well, I'm not suggesting we take it out. It's important to know what jurisdiction of organization is, but I think we can state it more simply. Any
based on New York.
anyone?
Maybe just paraphrasing or something. Organized, but restored.
Maybe-
Basically,
No.
just take it into one word or something.
Well, let's not keep it theoretical. I'm asking you to
Well,
propose something.
Well, you could say a New York
New York
corporation or
corporation.
something.
In New York, yeah, not or something. That's exactly what you say. This, I'm sorry, I'm annoying in that way. It's like, okay, what are we going to say? It's a New York corporation. No. A New York. It's not New York based. It's not a matter of where their address is or anything. They are a New York corporation. Yes.
The
Now,
office.
pursuant to is a wordy phrase that lawyers love. We'll talk later about this kind of wordy phrase. If only lawyers use something, then don't use it. But often, so you could say a corporation organized under or something like that, but often a wordy phrase like this is a sign to you that you should get out your machete and do more significant chopping. So, a New York corporation. Here is then English, an English introductory clause. You'll see, the English like breaking up their introductory clauses. Me, I'm fine with some single paragraphs. I don't. We'll talk later about how Commonwealth drafters like breaking stuff up. But even besides that, just weird things like why is that bold? Why is between bold? So you see all sorts of silliness in introductory clauses. Now I have to be careful. We're having too much fun. This slide, here's the scenario. It's a matter of how you date a contract. So here we have Acme and Widgetco that reach an oral agreement on the 1st of February about having Acme provide services to Widgetco. They need approval, so they can't sign the contract of the 1st of February. Widgetco says, okay, Acme, start performing now, and we'll sign the contract when the approvals come through. The approvals come through on the 1st of May, and it's your job to finalize the contract, and that includes putting a date for the contract in the introductory clause. You have a choice for the date of the contract. It's either the 1st of February or the 1st of May. Who would use the 1st of February as the date of the contract? That's the date the parties reach oral agreement and the date Acme started performing. Show of hands, 1st of February?
Excuse me.
Yes?
They start performing the.
Yes, they started performing 1st of February. So, show of hands, 1st of February? Okay. 1st of May, show of hands? I see one brave hand joined by my hand. I'm going to do the 1st of May, because that's the date of the contract. I mean, just as a fact of contract life, that's when the parties sign the contract. So that's when the contract is dated. You could say dated the 1st of May and effective as of the 1st of February, but I'm not even going to do that, because saying effective as of the 1st of February doesn't tell me what's going on.
What if you don't get the approvals?
Oh, I'm not going to venture into that, because my scenario, we have the approvals. If you don't get the approvals, you don't have a contract. And
So if you sign on the 1st of Feb,
you're not signing on the 1st of February.
agree to
I'm not. I'm dealing with my own scenario. I have my hands full with my own scenario. I can't explore other scenarios.
so what's your scenario again, sir? So you,
Acme and Wichco reach oral agreement on the 1st of February, and Acme starts performing on the 1st of February. Approvals come through on the 1st of May. Contract is signed on the 1st of May. I want to be more. I want to be clearer than just say the contract's effective on the 1st of February, because that doesn't tell the reader enough about. So what is this 1st of February? What happened? So what I'm going to do is I'm going to have the introductory clause, then I'm going to have with the 1st of May, then the recitals. We'll talk about recitals in a moment. I'm going to say the parties reached oral agreement on the 1st of February. Acme started providing services on the 1st of February. In the body of the contract, I might talk about compensation for pre-contract performance. And I'll certainly say somewhere that pre-contract performance is governed by this contract. So that way, I say what the facts are relating to the 1st of February, and I address how the contract relates to pre-contract performance. So I'm being more explicit as to what's going on, rather than just hinting to the reader that the 1st of February is relevant somehow. I want to be clear as to what's going on. I want to reflect reality.
Just a question.
Yeah.
Yeah. Is it a matter of law or a matter of just wording?
Is it a matter of law? No, it's it's a matter of my making clear what's going on.
Would you change this position if you are in a different jurisdiction?
Would I change this position if I were in different jurisdictions? No, because I don't want to win fights. That's, I should have that tattooed somewhere. I don't want to win fights. For the same way, I have people ask me, how have courts had anything to say about your recommendations? There's a longer answer to that, but the short answer is no, because my language is structured so that you don't end up in front of a court. The idea is to just leave courts out of it. So it's I want to say what's going on. I don't think this is anything that should relate to law particularly, but main thing is I want to make it clear what's going on, so we don't have to start consulting case law and trying to figure stuff out.
okay, aren't you exposed until the 1st of May?
Oh, hey, sure. But, yes, I'm not recommending this as an approach. Ideally, you just you sign the contract before you do anything. But I hear endlessly from companies that that's just the way the world works, that often enough you find yourself doing, involved in a contract relationship, before you have a written contract. So I'm not recommending it, just that's the way the world works often enough. So you have to be prepared for it. The general principle here is that there's the date of the contract and timing of performance. Don't use a fake date for the contract to reflect timing of performance. whether the performance started earlier in the way we just discussed or starts later. You could say, you know, you hire someone who's going to start work in a month. You could say, oh, contract is dated, effective as of October, whatever. No, I'd say it's dated today, and I'd say in the body of the contract that whoever it is starting work in a month.